D. Start balancing equity in a rent control case between the tenant Satish Ramchandra Bahekar and the landlord Sanjay Madhukar Savane. The Bombay High Court at its Nagpur bench has allowed the writ petition filed by the petitioner tenant who is photographer by profession at Digras in Yatmal district on August 4, 2026, but at the same time directed him to deposit entire arrears of rent till debt to the respondent landlord Savane, debts legal representatives within 3 months para. Thus, the High Court has come to the rescue of the petitioner and protected him from eviction from his photo studio and also took care of the landlord's interest. In the judgment, Justice Pravines Patil has observed that in view of mandate of section 15 subsection 2 of the Maharashtra Rent Control Act, the High Court has allowed the petition. However, the fact cannot be denied that the petitioner is enjoying the profession of suit shop since long without payment of the rent regularly para. Therefore, to maintain equity, the facts of demand that as per mandate of section 15 subsection 1 of the act, the petitioner must be made to pay rent till date as per their decided rent or the rent which was paid lastly by him to the respondent. The High Court has quashed and set aside the impugned judgment and order passed by the District Judge 1 Darwa in Yatmal district on March 6, 2017. In the background of pleadings of both the parties, the trial court decided the suit on October 17, 2013. It negated the submission of the petitioner in view of the evidence placed on record by the respondent. The court below specifically held that Dr. Arun Savane, to whom the rent was alleged to be paid, has categorically denied of receipt of any amount towards the pagadi as well as the regular rent. The petitioner also failed to produce any documentary evidence to demonstrate that rupees 1 lakh was paid towards the pagadi and regular rent to the brother of the respondent, Dr. Savane. As such, all the contentions raised by the petitioner were rejected. In respect of bona fide need, the trial court has held that landlord is the best judge of the requirement and it is for him to decide how and in what manner he should live and if he desires to beneficially enjoy his own property. It is not for the courts to dictate to him to occupy such premises, and in such cases, it is not necessary for the landlord to establish necessity. It is enough to show that some need exists para. In the present case, as the landlord desires to start his business for wife, the decree on bona fide need cannot be refused. In respect of finding about the tenability of the suit without compliance with section 15 subsection 2 has recorded finding that as per section 15 subsection 2 what is requirement is that the landlord shall 90 days notice to the tenant. The trial court allowed the suit with direction to the petitioner tenant to deposit the arrears of rent for the period of January 1st, 2009 to February end of 2011 at the rate of rupees 1500 per annum and future interest 6% per annum from the date of decree till its realization.